The rules allow the parties to ask for, and often get, a judgment on the merits at very early stages in the litigation. The first such stage where we discussed this was in the context of the motion to dismiss. When the defendant files a 12b6 motion, arguing that the plaintiff has failed to state a claim, what he's really saying is that even if we take all of the plaintiff's allegations as true, he loses. In other words, the case has no merit. The second such opportunity is at summary judgment. Rule 56 allows any party to seek summary judgment as to any one or all of the claims in the case at any time right up until the end of the discovery phase of litigation. The person claiming summary judgment must demonstrate that there are no material facts in dispute, and hence there is no reason for a trial, and that the party requesting summary judgment wins as a pure matter of law. For example, Jessica punches Jennifer in the face in public in front of many witnesses and breaks her nose. There really isn't a whole lot that Jessica can say in her defense, and because there are a lot of witnesses, even if she does, we're not going to believe her. If for some reason the parties cannot settle the case, Jennifer will move forward and will probably receive summary judgment as soon as she can enter the witness testimony into the court. The way it works is that both sides will submit briefs arguing that there is or is not material dispute on the facts. Sometimes both sides will argue that there is no dispute on the facts. When that happens, both sides will file motions for summary judgment. In that instance, each party will argue that why they ought to win as a matter of law. Here's the important point and what you need to take home. The court is not sitting as a finder of fact at the summary judgment stage. Its first job is to find out if there are any facts in dispute. If there are, the motion for summary judgment is denied. This is true even if the court is highly inclined to rule for one party on both the facts and the law. And it's also true if both parties are saying that there are no material facts in dispute. If the court determines that there are material facts in dispute, both motions for summary judgment are denied. However, if there are no factual issues to decide, the court can and will go ahead and decide the issues of law. Note that claiming that there is a factual dispute does not make there be a factual dispute. That was the standard at the 12b6 stage, where we said that all the plaintiff has to do to survive is make sufficient allegations. Here, the party trying to defeat summary judgment has to produce some facts. Back to our hypo. If Jessica claims that in fact she didn't punch Jennifer in the face, and she claims instead that Jessica's bleeding nose was due to a low-flying plane, and that all of the witnesses were drunk, she's going to have to produce some evidence of low-flying planes and alcohol. If she's not able to produce any evidence relating to low-flying planes or alcohol, we're going to show her the door and to bill for her victim's damages.